Good afternoon, everyone. Thank you for joining us here at the Vancouver International Arbitration Center for our webinar regarding a pilot project that's been launched as a partnership between ICBC and the Vancouver International Arbitration Center to handle cases involving personal injury arising from motor vehicle accidents. We are going to cover off a variety of topics related to this today, and I have an esteemed panel to help me do so. So without any further ado, let's introduce our panelists and move to the next slide. You'll see that joining us today, we have we're on slide 2. We will be hearing from Robert Warner, who's the ICBC Director of Claims Legal Services, first called to the bar in Manitoba and then British Columbia in 1990. He was in private practice prior to joining ICBC in 1998. And as mentioned, is the Director of Claims Legal Services, the area responsible for ICBC's tort litigation. He was the recipient of the Canadian Corporate Counsel Association's Award for Innovation in 2020. Also joining us is Jonathan Eads, QC. He has 2 decades of arbitration experience as counsel overseas as well as in Canada. He serves as co-chair of the BC Attorney General Ministry's Arbitration Advisory Group and helped coordinate major revisions to BC's International Commercial Arbitration Act 2018, as well as the complete overhaul of our Domestic Arbitration Act in 2020. He's appeared as counsel in several of the leading Supreme Court of Canada cases considering the interface between arbitration and the courts, and was named Queen's Counsel in 2021. And finally, we'll also be hearing from Joe MacArthur, who's an arbitration partner with Blakes, Castles, Braden, LLP, better known as Blakes, regularly advises on domestic and international arbitrations as counsel and is available for appointment as an arbitrator. He is chair of VanIAC, our organization, and is a member of our domestic and international arbitration panels. He's also on panels of other international arbitration institutions, and his counsel work focuses on significant infrastructure, mining, and commercial contracts. He is a fellow and a chartered arbitrator of the Chartered Institute of Arbitrators and national vice chair of CIARB's Canadian branch and the chair of CIARB's Vancouver chapter. Moving to slide 3, maybe I'll just say a bit about myself. I'm the managing director of VanIAC, called to the bar in 1993, and did a 16-year tour of duty of British Columbia's legislature and left as Attorney General for British Columbia. So just to give you an overview of the topics we'll be discussing today, we've had a number of discussions going back over more than a year ago with the Trial Lawyers Association of BC, some representatives also of the Canadian Bar Association in British Columbia, as well as lawyers with the Ministry of Attorney General and ICBC, and have developed, as mentioned, this pilot program with ICBC. And really the intention here is to gauge through this pilot program whether there is interest from the plaintiff's bar in voluntarily, consensually moving lower value motor vehicle cases towards arbitration out of the courts. The terms of the offer that ICBC has put together will be reviewed in this presentation today. And following the introduction of each major term, our panelists will provide teaching points and how these terms that are up for discussion today compare and contrast with standard commercial arbitration cases, because there are some differences that have been adopted for this pilot program. Irrespective of whether ICBC's arbitration offer is accepted in a particular case, you will learn in this webinar about the arbitration process, VanIAC, that's us, and BC's new Arbitration Act of 2020. Some of you may have previously heard, may be more familiar with our previous name, because we were established in 1986 as the British Columbia International Commercial Arbitration Center. The timing was deliberate. It was coincidental with Expo 86, and it was part of a move by the provincial government of the day with support from the federal government to try and make Vancouver an international financial center and to kind of piggyback on the global exposure British Columbia and Vancouver got as a result of Expo 86. Our board of directors chose to change our name to Vancouver International Arbitration Center, a somewhat more streamlined name, recognizing that globally, Vancouver has greater name recognition than the province of British Columbia, and that's certainly something we experienced when we were hosting the Winter Olympics. Vancouver's name brand became quite well known around the world through all that effort. So changing our name as an organization takes advantage of that. So I think at this point, we can move to our next slide. And I will turn it over to Robert Warner at ICBC to take us through some of the highlights that are incorporated in the offer to arbitrate that ICBC is extending to certain types of motor vehicle act cases, and perhaps Robert can tell us in what circumstances those offers are extended.
Great. Thank you, Barry. Appreciate that. So good afternoon. What we're going to do on this slide is a snapshot of the offer to arbitrate. So we're going to review most of the terms of ICBC's offer to arbitrate as we go through the module. So a bit of background, and I think Barry, you touched on this, but work began on this pilot project after the pandemic stopped or limited the number of trials that were proceeding. A backlog was developing, and a question being asked was what might be done to help those who had lost their trial dates and to reduce the impact of the adjourned trials on the trial calendar going forward. So really the impact on the courts. So again, start with a snapshot of the main features of the offer. So the offer is an offer that will be extended in cases where ICBC is prepared to arbitrate. So what we're doing is we're running a pilot project where we hope to arbitrate 25 cases. And then in the arbitration of those 25 cases, we hope to learn where we might have opportunity to go more into this area of an alternative dispute resolution. So our focus is on using arbitration to resolve actions where the litigants were ready to proceed to trial, only to have their trial adjourned. So we're making an offer to arbitrate, and if the action proceeds to arbitration, it will be because the litigants agreed to the arbitration. The arbitrator will be able to make an award up to $200,000 with some caveats to that we'll deal with further in the presentation. The arbitrations will proceed under VanIAC's expedited arbitration rules, except to the degree to which the rules are modified by the terms of ICBC's offer to arbitrate. And again, we'll be talking about that today. Arbitrations are going to be completed in 1 to 1.5 days. The arbitration will be 1 day unless the arbitrator decides that they require another or an additional half day. So there's rules around the evidence and around arguments so that the time restrictions or the time box makes sense. There's a flat fee agreement for the arbitration process, and we'll talk more about that in the course of the presentation. So I think we're ready to move on to the next slide.
Thanks very much, Rob. I'm going to just identify a couple of the advantages that come from the ICBC arbitration, at least the pilot project. And a lot of those advantages really reflect some of the advantages that you find in commercial arbitration, which is what I'm more familiar with. And little caveat to start off, I am not a personal injury lawyer and don't have the experience that a number of you on the call have. But what ICBC, the arbitration pilot project offers is a choice of decision maker who is a subject matter specialist. So you won't find me on the list of arbitrators for this program, but you will find a list of former judges, a number of senior counsel with great experience in personal injury. And one of the things that gives you an advantage here is not only that list, but you're not just getting some random judge from the BC Supreme Court appointed to your case. You've actually got someone who's going to have that subject matter expertise coming into it. So that's one of the advantages that this program offers. Another is, unlike BC Supreme Court, depending on when you enter into the arbitration process, you'll have a continuity of your decision maker. So you won't have, for example, your trial management conference in BC Supreme Court will be often in front of someone different than your trial judge. And applications that happen to occur before the trial are usually before someone who isn't your trial judge. Here, any applications that happen before the hearing, anything that happens before the hearing, the decision maker will be privy to, and will see that all the way through the hearing. So it's that continuity of decision maker, which is one of the advantages of arbitration generally, and certainly of this pilot project. Another advantage is that it is a private process. You don't appear in court, obviously, or in any kind of a public forum, and this provides some comfort for witnesses, frankly, who would rather not appear in the formality of the court process. It's more of an informal process. There's still some formality to it, but not quite the same as in court, and it is private. You won't have strangers walking in to the hearing room. In fact, there won't be any strangers there. Similarly, just going over to the next slide, thanks, Sina. The outcome is confidential. So unlike BC Supreme Court, if you're on the plaintiff side, your client isn't going to have the details of their life and their injuries over the past 3 or 4 years set out in a detailed judgment on the BC Supreme Court's website. It is going to be a confidential outcome, a confidential award that will deal with these issues. So there's not only is it a private process that people aren't allowed into it, it's also confidential, the outcome. There is a speed, and there are significant speed advantages to arbitration, and the pilot project is no exception to that. Things move much quicker than they do in court, and typically means a shorter time commitment, particularly once you get to the hearing stage. As you'll see, the hearings, as Rob mentioned, the hearings are limited to a day and a half, much shorter than your typical MVA trial, whether it's a 5-day or a 10-day trial. You're not going to get much shorter than 5 days sometimes, but this is going to compress things, I think, in a way that still leads to a fair result and a fair hearing. And finally, finality, there is no right of appeal to arbitration awards, and we'll get to ICBC awards as agreed to by the parties. And we'll get to that in a bit more detail, but generally speaking, after the arbitration award comes out, that's the end of the road.
Okay, so the why, again, the court backlog, right? So the work began on this pilot project when the pandemic started. So from our perspective, we're looking at what might be done to resolve some of the claims that were likely to result in a trial down the road. Now, there was a Vancouver Sun article that came out in early January, and in that article was noted the province has made good progress to reduce the COVID-related backlog. So while the backlog is not as concerning as it was early in the pandemic, it still makes sense to us to do what we can to reduce it. The second bullet highlights that plaintiffs may be looking for a process where they can get, and I'll quote it, hearing on the merits carried out quickly, efficiently, and finally. As noted, the focus of our offers to arbitrate, or what we call an ODA, has been on actions where the litigant lost their trial dates. So these are actions where the parties were ready to proceed to trial, actions where the rescheduling is likely to be many months, perhaps years down the road. So on our end, there's an appeal to having these low-value claims heard by an arbitrator. Now, why is that? Well, the litigants ready for trial. Should be easier for the evidence to be marshaled for an arbitration. Examinations for discovery has been completed, expert evidence has been exchanged, transcripts have been ordered. The parties will have secured the evidence they require to properly represent their client's interests. So we think this is a type of claim that makes sense from shifting from a litigation to an arbitration perspective. For the purposes of our pilot, the focus is on bump trials where the plaintiff is seeking damages up to or equal to $200,000. So that's the cap on what the arbitrator can award. Looking at it from an innovation perspective, I think it's important to note that arbitration of motor vehicle accident related personal injury claims isn't something that ICBC has done in the past. For the most part, our experience with arbitration has been with our underinsured motorist protection cases or UMP claims, which I suspect many on the call or on the presentation are familiar with. So to a large degree, this is new territory for us. So running a pilot program to see what we can learn from the program. How does the process work? How will it impact litigation costs? What's the results of the process? Is there more opportunity? Essentially, to what degree does this make sense for us? So the pilot project of 25 files. So our pilot project's limited to 25 arbitrations. Now the intent is that once we've done the 25 arbitrations, and we're hoping that we'll be able to get there, we're then going to review how the arbitrations have proceeded to see where we go from there. We began the pilot project back in May of 2021. The offer to arbitrate sets out the terms and conditions that we're prepared to agree to proceed to binding arbitration on. And what we plan to do with this presentation is to send out a copy of the offer to arbitrate so that those on the call can take a look at it. So capacity, why 25 cases? Again, new process for a defense counsel. There's likely to be a learning curve. It's actually, quite frankly, a new process for plaintiff's counsel as well. We don't have an understanding of the legal expense incurred in preparing litigated files for an arbitration process. We don't know what the appetite's going to be for this. We don't know whether 50 to 200,000 dollars is the right bracketing. We don't know what better ifs might come out of this from a process perspective. We have volume considerations in terms of what's reasonable for us to be able to look to arbitration as a process that we can engage in. And then what's the impact on our metrics, or severities, legal spend, et cetera? And are there any unforeseen impacts? The bottom line from my perspective, or from ICBC's perspective, is it has to be palatable for ICBC and our ratepayers at a price point that makes sense to us. So the reality is that this is the type of claim that we believe makes sense. So I think we're ready for the next slide.
Yeah.
Thanks, Rob.
Oh,
Go ahead, Joe.
No, Jonathan, you go ahead.
Well, I was going to lead into the next point, so Joe, it's all yours.
Well, I was just going to say that, you know, so the offers, as Rob said, the offers are made to cases that are bumped. So there's already a BC Supreme Court action that's been commenced, and the arbitration replaces that filed BC Supreme Court action. And this is somewhat unusual, but it does happen from time to time in commercial arbitration, where a BC Supreme Court action is commenced, and then the parties agree, have a separate arbitration agreement to move that dispute into arbitration. So it isn't unheard of in the commercial arbitration side of things either. But Jonathan, you might have some more to add in terms of the comparison.
Thanks very much, Joe. I wanted to say thanks to VanIAC and ICBC for working with the Ministry of Attorney General on something that's innovative and is different. And ICBC is really prepared to try something different, work with our brand new Arbitration Act, which is performing very well, and try a novel approach. And so, yes, it is built off a commercial arbitration model. As Joe says, it does happen that trials, cases which are ready for trial will be bumped by party consent to commercial arbitration. But often, the normal way in a commercial arbitration, you'd of course have a contract and you'd work up your claim from the beginning through until the arbitration. We do think this is adaptable here because the hard work will have been done by the parties who are ready to go to trial, and then have the file picked up by consent before an expert arbitrator to take it forward. Ready for the next slide?
Actually, if I can just jump in before we go to the next slide, just really briefly. So our view is the actions are unlikely to resolve. If there's going to be a negotiated settlement, odds are that it would have happened before the trial. So the litigants had to wait for the original trial date. They're now waiting for the second one, and again, with a low likelihood of a negotiated settlement. So this is one of the reasons that we think this is the appropriate subset of files for mediation, or for arbitration. Both parties have availed themselves of the rules of court in terms of what was provided for process. And these are the cases that should be more easily put into arbitration form, in that trial prep's pretty much already been prepared. And because they weren't resolved earlier on, these are the actions that are likely to become a call in court time if they're not resolved other than by the arbitration process.
Yeah, that's right, Rob. And I think one of the real advantages here for parties who select this process is, again, this is building on points that Joe noted already, but you're getting from the arbitrators, a list of specialist judges who have specialists in personal injury law, and personal injury lawyers have set themselves up and put their names forward to VanIAC that they're ready and willing to hear these cases. So that's something one cannot get in court. You don't obviously get the ability to choose your judge. Here, you've got already a pre-culled group, and then the parties can agree on an arbitrator amongst that group. That's a tremendous advantage. Now, commercial arbitration has that advantage too, but what you often don't have in commercial arbitration is a pre-culled list. You have the parties can get whomever they want. Here, you've got a list ready and willing and able to go, which is a great value add, I think, by VanIAC to this class of arbitral cases.
And so the way that this kind of works is VanIAC administers the arbitration. What that means is, for counsel at least, for the most part, is VanIAC kind of acts like the registry. If the registry had a lot more time and ability to deal with your cases, frankly, our staff does an excellent job and is available to assist with any issues that arise during the arbitration. We also have the VanIAC expedited rules. These were adopted in 2020 when the same time as the new act came in. It's our new domestic rules, and they apply to a wide range of cases. The limit is slightly different. It's cases under 250, commercial cases that come to the center all go through the expedited rules for the most part. And we've had great success with that. Parties have been very happy with these rules, and they're basically taking you from start to finish in 6 months for a commercial arbitration, which is great timing, and people appreciate the speed and efficiency of it. These have been modified. The rules that we have been modified somewhat by ICBC's offer to arbitrate. Again, that isn't that uncommon in the commercial sense. You would often see parties modify the rules to suit whatever their particular case is at a given time. And that's what's been done through the offer to arbitrate as well. I'm not sure, Jonathan, whether you want to add to that as well.
I would just add this for this, and we've got a great group of people who've joined in with many diverse backgrounds. We've got people who are arbitrators and a lot of plaintiffs' injury counsel. For the commercial arbitrators here, they may know this, but for people who are looking at the Arbitration Act or VanIAC's rules for the first time or not too familiar with them, really the Arbitration Act, which was massively overhauled in 2020, does something the old act did not do. You could not read the old Arbitration Act and actually understand very much about the conduct of an arbitration. It was counterintuitive. It was not user-friendly. The new Arbitration Act effectively tracks the progress of an arbitration right from arbitral selection right through to the hearing and any potential challenge, which Joe has said there is no appeal in this particular process. But you can learn a lot simply by, and arbitration is a skill set that really litigators need to know. Just by looking at the act and looking at VanIAC's rules, you can learn so much that you couldn't before. It was designed for that purpose. We, in the province, wanted to make arbitration more friendly and more amenable to a broader class of disputes and not just to specialist practitioners. And so here ICBC has come along with a novel and good use of making use of that arbitration legislation in a new setting.
I'll just add, sorry, one addition. So we're going to share out a copy of ICBC's offer to arbitrate, and ICBC is going to be extending the offer in particular cases, and obviously reserving the right to adjust terms. But what I would add to that is, if you have a client who is interested and you have a concern with any of the terms, let's have that conversation. I don't want to prejudge what that might look like, but we're interested in having some arbitrations actually proceed in our pilot. And to that end, if there are roadblocks on your side that we need to talk through, let's have the conversation.
Thanks, Rob. I mean, that's just one of the beauties of arbitration that Rob has just emphasized right there, that it's a process which is created with a legislative structure in the background and the rules, but the parties can agree on much in the ways you can't do as easily in civil litigation. So it's amenable. So I would take up that offer for people who are interested. What about the hearings themselves? I think a question might be, how can you possibly have a hearing of a matter in dispute in one day, which could be extended for half a day? You'll never get it done. And I know that the thinking, because of course I've litigated as well, arbitration hearings are not like court hearings. Arbitration hearings, the evidence has come in by way of witness statements in advance. You've got the materials in front of an expert arbitrator. So, and including in this personal injury context. So what you are doing at an arbitration hearing is cross-examination. It is a cross-examination intense hearing. That's it. And it's long days too, that one day you can get through. But for example, like starting court, 10 o'clock, it's a couple of breaks in the day, it's done by 4. That is not the arbitration norm. The parties and the arbitrator can decide when that day starts. I've had days start at 8:30 and end at 7 p.m. You can have a very full day of intense cross-examination in that period and bump over with discretion to another half day. So it's quite remarkable. I'll just give an anecdote, which I shared with our colleagues the other day. They have the same experience. I just came out of a six-day hearing late last fall. 6 days, no big deal. The other side and I compared notes during the hearing. We said, how long do you think it would have taken to have this matter heard if we had done it in a conventional civil trial? And we both agreed 5 to 6 weeks. That's how tight it can get in arbitration. So you can accomplish a great deal if it's exclusively limited to, as arbitration is, a hearing, to cross-examination.
And if I could just add to that, and it's might as well go to the next slide because it's detailed here a bit too in terms of how the evidence comes in. But again, keep in mind that you have an arbitrator appointed already. So evidence is coming in, and the arbitrator, before you get to the hearing date that Jonathan's talking about, before you get to that hearing, the arbitrator will have read all the evidence, will have read arguments already. So the arbitrator comes in like a hot bench, as I think they like to call it at the Supreme Court of Canada, where they're ready to go. And that actually helps to, again, narrow the issues, both from the parties, because they've seen everyone's position, but also for the arbitrator, they can help direct the parties to what they're really concerned with, both with respect to the cross-examination and eventually with respect to closing arguments. So the approach is very similar, again, to our expedited procedures with some limitations placed on it. It's direct evidence by witness statements. Here they'll be sworn. They'll be limited to 40 pages, not including attached exhibits. Collateral witnesses are limited to 10 pages, again, not including attached exhibits. And witnesses must attend for cross-examination if requested by a party. And the thing that I've found over time, it might take people time to get comfortable with it, but in arbitration, it's much more common, especially in the international context, but more and more so in the domestic context, for parties not to call people for cross-examination. And that really saves a whole bunch of time. And you have to decide whether or not it actually makes sense to bring people in for a very short cross-examination. And often counsel make the decision not to, where they're not crucial. Time limits on the cross-examinations will be set by the arbitrator, depending on the length of the hearing dates, and as Jonathan mentioned. And the opening and closing arguments will be written. If there's major objections about expert reports and so on, those may be in writing as well. And so this is all similar to what you'd see, again, in a commercial arbitration, especially one under our expedited rules. And as Jonathan says, it's amazing how much you can get done in that hearing date. The hearing becomes much less the same focus as the trial, because a lot of the work is done beforehand with this written material. I think that's you, Rob.
Sorry, 1 second.
Yeah.
Okay, so our offer, our ICBC's offer to arbitrate provides that the Evidence Act applies to arbitrations. So that's the limits on the number of experts that are set out in the disbursement and expert evidence regulations. So that's what we're talking about there is a 3 expert report rule, again, subject to the transition provisions. Something that we talked about in the pre-meet prior to this presentation was the cap on disbursements. And one of the questions that came into Barry prior to the presentation was this question. I'm going to read it. Probably first on the list of questions here for the plaintiff's bar would be whether the disbursement cost associated with the arbitration is caught by the NDP's 6% disbursement cap. So I thought I'd take that on here. Obviously a great question. The next slide sets out the arbitration cost, and they're not inconsiderable. We're prepared to agree for the purposes of the pilot project not to include the cost of the arbitration as a disbursement. So the expense won't form part of the disbursement in the 6% cap. That said, the 6% cap will apply to disbursements otherwise. On a side note, I think the petition challenging the 6% cap now has a date set for hearing. I think it's being heard by the Honorable Mr. Justice Smith on March 3rd and 4th of this month, and we'll have to see how that plays out.
So here we are with costs, and costs are a little bit different than they are in a commercial arbitration context. You've got fixed fees. Your arbitration fee for VanIAC is $950. 1 day cap on arbitration fees of $11,000, and then additional half-day arbitration fee of $2,750. Now remember, for the 1 day arbitration fee, because the arbitrator, as Joe explained, is getting the materials in witness statement form beforehand, they're doing a workup in advance. So they're getting paid for their 1 day fee, but they are doing more work in advance to begin with. So that's different than commercial arbitration. Commercial arbitration, you would have administration fees with VanIAC if you have VanIAC administered arbitration, which I highly recommend. The arbitrator, you would normally agree to, the arbitrator would have a fee schedule that they would propose, usually hourly, not always, sometimes flat fees, and usually not based on the hearing date, but just on the total work up on the file. So there's a difference there. This fee, though, remember, you're getting an expert decision maker. I think is one of the key points here. Someone who has a specialty in this area. That's an advantage for the parties. It's an advantage for the time that the arbitrator is going to have to put into the file as well. This will not be the first PI case that they've worked on, far from it. Next slide.
Okay, so I'm just going to address a point on the slide you just spoke to, and that was on the list of arbitrators that are available on the panel. And just we will be sharing the list for those that are interested in seeing the names on that list. It is a very impressive list, and there's a lot of subject matter expertise that's obviously going to be very valuable here. Okay, arbitration offer. So again, you've just seen the cost of the arbitration. It's not inexpensive. It's important to us, this being ICBC, that there be cost consequences for the parties. Hopefully the cost consequences will help resolve some claims without need for an arbitration. We believe it's important to encourage the parties to make settlement offers. So it's important to us that there is an exchange of offers as a precursor to the arbitration, or at least cost ramifications for a litigant who opts not to make an offer. A through C are pretty self-explanatory. So A is an equal sharing of the fees if the award is between the parties' offers. B, if the award is equal to or greater than the plaintiff's offer, the defendant pays all of the fees. C, if the award is equal to or lower than the defendant's offer, the plaintiff pays the fees. So our experience to date, when we've made offers to arbitrate, has been that there's a number of cases where we've made an offer to arbitrate only to hear that the matter is resolved, or that there's settlement negotiations that are continuing despite the trial not proceeding. And usually what we have there is one of two outcomes. Either the plaintiff's counsel wants to have the offer left open to see if the negotiations result in a settlement, or they're not interested in the arbitration process. There are other cases where the parties haven't been able to secure a new mutually acceptable trial date, and there are others where the plaintiff is not prepared to have their claim limited to the $200,000 cap. We do the best that we can to identify the files that we think fit within the $200,000 cap, but really what we have to work on are the plaintiff and the defense's last numbers prior to going to trial. So we do the best we can. Again, talk to us if you want to have a conversation about why this might be something that your client may be interested in. We believe it's fundamentally important to us to have the cost of the arbitration being paid by or shared by the parties based on the outcome of the arbitration relative to litigants' pre-arbitration settlement positions. Our view is that the ICBC ratepayers shouldn't be solely responsible for the cost of the arbitration. What we want to encourage is that both parties have a reason to be as reasonable as possible, so that we can have them minimize the need for an arbitration, as we believe the cost consequences are reasonable and necessary. So we think we're driving the right behavior with this, and we think it works in both parties' interests in terms of trying to get to a number that makes sense, and where we don't or we can't, to make this as easily packaged for an arbitration as possible.
So in terms of the award, as discussed, the arbitrator's got a limit. The award cannot exceed $200,000, not including interest, costs, and VanIAC administration fees. And that again is somewhat similar to what we have for our expedited procedures for commercial cases under our expedited rules. There is a limitation there in terms of the amount that can be awarded. There's some exceptions that apply, but that's the usual rule. Like our expedited rules, there is no right of appeal. So under the new act, the new Domestic Arbitration Act, the parties can agree that they will not appeal the outcome of any award. And here, that's what the offer to arbitrate contains that as a term, and that is one that would be binding. So what you'd be limited with is your rights of to apply to set aside the award, which is slightly different. So the right of appeal is a right of appeal on a question of law that you can bring with leave. Now under the new act, you would bring it with leave from the Court of Appeal, from a single justice of the Court of Appeal, and that's for commercial cases that haven't agreed to opt out. Now, the meaning of the ICBC offer to arbitrate includes an opt-out, which is also, again, what we do with our expedited rules. If you proceed with our expedited rules, you're agreeing to opt out. And that really narrows the issues. This should really create a real finality with respect to that award, and what the arbitrator awards should be the end of it. The applications to set aside an award are very narrow. You think of it as kind of natural justice or fraud type issues, and the success rate for those is minimal, and typically parties don't bring those types of applications. And so really the ones that you see more often are ones on a question of law, but those wouldn't be available to you in the case of an arbitration brought under the ICBC pilot project.
So I'm going to talk about the award, but I'm just going to go back to a point which I don't think I covered off fully last time, is legal costs. Legal costs are not determined by the Arbitration Act, actual reasonable legal fees. That's the norm in arbitration. The ICBC offer instead offers the costs will be decided as they are in civil litigation on the tariff basis, on a bill of cost basis. And that makes perfect sense in this context, because so much of the work that's gone into the preparing the case was prepared as if this matter was going to trial. So that would apply. So you also would not appear before a registrar to tax a bill. That process instead would be put forward to the arbitrator, who would decide issues of legal costs. So, and then in terms of the arbitral award, this is really the name of the game in arbitration. That's what the parties want. Just like you want a judgment, we don't use the term judgment in arbitration. It's an award, and if you've gone through the process, you don't have an award unless you've settled it. It's not worthwhile. You want that award, because that award can be easily enforced, just like a court judgment. The Arbitration Act puts that out there. And so there's limitations on the award here. which again, the beauty of arbitration, you create your own process. And the arbitrator is directed to a 15-page award or less to be provided within 30 days of the conclusion of the hearing. So again, it's going to be tight, it's going to be short, and it's going to be over. The Commercial Arbitration Act doesn't provide such limitations. Parties can create that, but there's no presumption that you would have a 15-page award or would be decided, rendered within 30 days of the hearing. Again, the parties have that flexibility. The default is no specification, but you can create whatever process you want within reason. In commercial arbitration is one of the beauties of the process. Next slide. Barry, wrap up.
So I think this is me. We're a little bit ahead of schedule, which is good, and it demonstrates the efficiency of arbitration. We don't have to use up all of our time, but I should have said at the outset that we do welcome your questions. There is both a chat and a Q&A feature through Zoom. Feel free to make use of either. We've had 2 questions come in thus far through the Q&A feature. I trust the answers are adequate. One question came in, right? The second one was about the opportunity to challenge an award. And I think the send button on that question was hit just as Joe was talking about right to appeal and so on. If that answer was not fulsome enough, I'm sure Joe could add a bit more. Putting you on the spot there, Joe. And then the first question had to do with what if the parties cannot agree on who the arbitrator will be? And I took a stab at answering that question in the Q&A feature. But if you have any other questions, anybody would like to submit or any further clarification, this would be a good time. I should also note that this initiative kicked off, as Robert mentioned, at the outset of the pandemic and when the courts were closed for in-person hearings. Our previous chair and I, Les Meroff, and I reached out to the provincial government at the time, as well as to the Chief Justice of the BC Supreme Court, to offer our services to try and help relieve some of the pressure of the backlog. And this has led to this initiative. So I do want to just recognize the many hours that Les Meroff put into this proposal. So thank you for that, Les, and I think you might be watching today. And one other housekeeping note, this session is eligible for CPD credit. It has been authorized by the Law Society of British Columbia, so you can submit a claim for credit for this.
Barry, can I jump in and answer that question that Joe might have fielded, which is the ways to challenge an arbitration award? Because we'll talk about commercial arbitration generally. There's 2 main ways. One is the appeal, and that's being opted out here. There is no right of appeal. The new Arbitration Act allows that. The old Arbitration Act did not. But let's imagine we're in commercial arbitration, just so we're talking about this. An appeal in commercial arbitration under the Act can only be brought on a question of law. The questions of fact, the questions of mixed fact and law, only a question of law, only with leave from the Court of Appeal. The set-aside application would be brought for serious proceed. That's one way. Set-aside applications number 2 would be brought to the BC Supreme Court. You can't contract out of that. That's for serious and gross procedural irregularities which undercut the reliability of the arbitral award. As Joe said, very difficult to achieve that, but you've got to obviously have that bare minimum procedural protection for the parties. When something has gone massively awry in the process, there would be recourse. So those are to kind of answer that question, there are the 2 main avenues of attack upon an award. Within the arbitral process itself, problems can come up though. What about arbitral bias in the middle of the hearing? Is there a challenge procedure for that? Yeah, there is. It's set out in the Arbitration Act. So there's that type of process as well. What about when you've got just arbitration generally? What if you've got an arbitration agreement and then someone runs off to court and starts the same process in court? How does arbitration deal with that? There's a stay proceeding, which is set out in the Arbitration Act. It's a well-oiled machine. That has not changed in BC's new Arbitration Act. We've got the same process effectively we've had for 40 years. We've got very good jurisprudence in British Columbia, which would stay the civil action pending the outcome of the arbitral hearing. And usually it's just stayed for good because that's how the parties have decided to raise their disputes, resolve their disputes. I just thought I'd touch on those key main interface points. There are others, but those are the main ones between arbitration and the court process. Joe, anything to add to that?
No, that was helpful, Jonathan. So, and to be clear, in this process, you've given up that right to appeal, but these other protections that are there, you do have the other protections that are in the Act in terms of a set-aside application and the other things that Jonathan has talked about.
That's correct.
Thank you. That's very helpful. We did get a further question just now, whether this webinar will be available later, a recording of it. And yes, it is being recorded. And our intention is to make it available. I believe it will be posted on our website. We are also intending to follow up with everyone who is watching us today with an email, and we'll provide you with a copy of the offer to arbitrate, so you can take a closer look at the terms at your leisure. And again, we'll forward that information to you. You can look forward to that in your inbox. And if that generates further questions, then please let us know. And I also want to recognize the person you're not seeing on screen, but who is instrumental here, is Ina Ergashiva, who's busy behind the scenes, handling the cases, and she's our assistant director here at the center. And so if you have further questions, she will be likely involved in helping answer, and I will help out as well. I see in the meantime, we've had a couple of additional questions come in. A question all the way from across the ocean in India. Someone is practicing law there and wondering how they can get involved with practicing arbitration with VanIAC. I do invite you to send us a follow-up email, and we will reach back to you with some information. There's a process involved in terms of getting involved with our organization. Lawyer Luke Zacharias, who hails from the very pleasant Fraser Valley, has a question about the rules regarding costs of arbitration, exposing the plaintiff, and whether they would not be exposed if the matter remained in the court process. The process seems to expose the plaintiff to half the cost of the arbitration, even if they beat the defense offer. Am I understanding this correctly? Put that question perhaps to Mr. Warner.
Yes, no, that's if the offer comes, or sorry, if the award lands between our offer and the defense offer and plaintiff's offer, yes, they'd be on for half of the cost of the arbitration. That doesn't relate to the cost of the civil proceeding, right?
You mean the civil proceeding to that point?
Yes, exactly. Yeah, it's really just dealing with the cost of the arbitration, right?
Okay, so maybe just complete that and fill in for us. So what would happen with the costs incurred to date as part of the civil action in the court?
They would be entitled to the cost in the civil action, just as they would be in a normal course of matters, right?
So the BC Supreme Court tariff would apply for that.
Yeah, BC court tariff would apply. Yeah.
And if the plaintiff is successful and the award exceeds what the offer was from the defendant, then the cost of the arbitration would be awarded entirely to the plaintiff, 100%.
Sorry, I missed that.
If the award exceeds ICBC's offer,
right, then ICBC would be paying for the cost of the arbitration, and plaintiff would get their cost.
All right, thank you. Mr. Zacharias, I hope that answers your question. If not, let us know. There's an anonymous attendee with a question. Will these arbitrations be referrals from the Supreme Court?
I think the answer to that is no, in the sense that in some jurisdictions, I don't think ours, there'd be times where the Supreme Court would actually refer something to arbitration. That would not be the case here. This is all between ICBC and the parties.
That's my understanding as well, Joe, and that's where it's like commercial arbitration. You've always got the option in a piece of civil litigation, a commercial matter, to opt out. Talk to your friend and say, let's arbitrate this. Let's just get it done. And that's what's happening here. But here, the offer is being extended in this unique circumstance where you've had the trial bumped, everyone was ready to go. The dollar limit and Rob Warner and ICBC are making the approach. Then open for plaintiff's counsel to accept that offer. If that offer is accepted, you have right then a binding arbitration agreement. You're ready to go.
Very good. There's a question about whether we'll distribute a list of who's on the roster for these types of cases for the pilot project, and the answer is yes. That will be part of the information that we distribute following this webinar. There's a question about whether the arbitration process applies where the claimant is a party outside of British Columbia in respect of an accident occurring within British Columbia, or is this process limited only to cases involving BC parties exclusively? I think I know the answer to that, but I'll turn to Rob for that.
Again, when we are issuing the offer to arbitrate, we'll be looking at cases that we believe are appropriate for arbitration. So, you know, if it's a case where there's multiple parties, for example, or complex or liability issues, we may not choose to offer to arbitrate those cases. It would depend on the complexity of the claim, whether that's somewhere we would go.
So, but there's not a bar to someone being from outside of British Columbia if the accident occurred within British Columbia?
Yeah, I don't see that there's a bar. I'd have to think that through some more. It's not a circumstance that has come up so far in the claims where we've been looking to offer arbitration.
Okay. I don't see any further questions at the moment. This is your opportunity if there's any further questions. I think we may have another one here. Gentlemen, do you see this? I'm not sure if our panelists can see these questions, but question is, my understanding, this is from Mr. Zacharias, my understanding is that if the plaintiff beats the defense formal offer, but does not beat their own formal offer, the plaintiff will pay half the cost of the arbitration. Would that be, I think that's what I heard Mr. Warner explaining. If it comes in the middle, then the parties split the cost of the arbitration. Is that right, Rob?
Yeah, equal sharing the fees if the award is between the two offers, between the parties' offers.
Right. And if the matter were in BC Supreme Court, would it be the same?
Sorry, well, if you're in BC Supreme Court, it would be likely
the judgment
case of a formal offer to settle made by the parties, and then your cost consequences would come out of how you do in relation to your formal offer. So again, if you're seeking double costs, it usually be a situation where you as plaintiff's counsel or you as defense beat your formal offer to settle, right? And the cost consequences would be attendant on that.
Right. Okay. And we do have a late breaking question from Mark Tweedy. Have any matters proceeded to arbitration under this pilot project thus far? And if so, what was the party's experience with the process?
I'd like to take that one on. So from the offers to arbitrate that we have sent out, we have no acceptances up until fairly recently where we have a claim where plaintiff's counsel is prepared to enter into arbitration, but they have some conditions, and we're now talking through those conditions. But as of yet, we don't have any that have gone through arbitration. And we're hoping that in part, this presentation will drive some more activity. We would really like to see some proceed to arbitration to see to what degree this makes sense and works for us and British Columbians.
Exactly, yes. Our hope is by raising awareness of this option that people will become more familiar with it and hopefully comfortable with taking up this opportunity.
And just to add to that, I mean, part of it is sharing some of the benefits that we've seen, especially with our expedited procedures in our new rules. The parties have been very happy with those. They're getting timely decisions and at a less expensive cost typically than in court. And the whole thing is getting wrapped up in 6 months. So some of that is, we really want to see if we can pass it on into other cases, which I think what this ICBC pilot project is all about.
I think that's a good point about arbitration generally, which is just surprising when you've practiced civil litigation. The timelines from a start to finish arbitration are rare is the case that goes over a year, and very common is the case that's 4, 6, 8, 9 months, tip to tail, started, finished, done, final award. It's hurry up litigation. It's actually a really fun way to practice law. Parties like it too, I find, because they get the matter over with. They're not. It's not lingering over them for years. And then when an arbitration hearing is set, you're not getting the last minute bump. The parties will have been through this in this very situation. By definition, they will have been bumped from the trial. They will have been ready to go, and then they can't go. That's not this situation. That's not how arbitration works. I mean, absent someone having this, a serious illness or a serious conflict, the matter goes ahead and it's done. And there's that savings. I always say that in arbitration. People talk, is it cheaper? I say it depends how you measure costs. If you're just measuring on legal fees, I don't think it is cheaper. Is it cheaper in terms of impact on your life and getting the thing done? I think it's definitely cheaper. There's no question. And not having having this litigation hovering over you, you get it done, and that's why it's a satisfying process to partake in.
I'll just add to that. I mean, in the cases that we're looking at are situations where we're looking at offers to arbitrate. So if the trial gets bumped, the reality is that if the litigants were going to go to trial the first time around, they're likely going to go there the next time around. And if that's the reality, you're waiting for your next trial date quite some time down the line, but you're going to have to prepare for trial a second time. You're going to have to meet with your witnesses. You're going to have to refresh your evidence, including your expert evidence. So I'd also suggest that there are some potential savings in this for both the litigants, both the defense and the plaintiff's counsel.
Right. So thank you very much, everyone. And noting the hour, I think we'll get ready to adjourn. But before we do, you will have heard Rob Warner pass a reference to UMP cases, underinsured motorist protection cases, which VanIAC is very much familiar with and involved in. It is a form of arbitration for a subset of motor vehicle cases in British Columbia involving ICBC. We will be hosting a webinar specifically on underinsured motorist protection cases on April the 21st. We haven't advertised that yet, but as soon as this event is over, you can look forward to seeing the opportunity to register for a webinar on April the 21st, all about underinsured motorist protection cases, which is something that is, again, something we're quite busy with at the Vancouver International Arbitration Center. So unless there's anything else from our panelists, I want to thank you all for participating. I hope you found this useful. But if you have any questions, feel free to contact us back using our email address. I believe it should be visible on the last screen, resolve@vaniac.org. Again, if you have any questions, just shoot us an email and we'll be happy to get back to you. And with that, I wish everybody a good day and a successful week. Thank you very much.
Thank you.